Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about storage of firearms. Cases that should have gone to the Supreme Court of Canada, but didn't. Tariq Rana was charged with 2 offenses related to the storage, transportation, and handling of a firearm that was located by police in his residence under the laundry. It was contained in a box, and the box did not have a lock on it, nor did the firearm have a trigger lock on it, contrary to the rules for storage of certain types of firearms in Canada. As a result, he was charged, but ultimately he was acquitted of the careless storage offense and convicted of some offenses related to the transportation of the firearm. At trial, Mr. Rana argued that the interpretation of the provisions of the legislation under which he was ultimately convicted was done incorrectly by the judge, arguing that the word individual and the word transport were given an overbroad and inappropriate meaning by the judge. And this case raises important issues, especially as we see many changes coming to firearms legislation in Canada in the last couple of years. The Supreme Court of Canada had the opportunity to get ahead of what is likely going to be a significant area of challenge, the interpretation of various different words in the firearms-related statutes. And had the Supreme Court of Canada taken the opportunity to interpret these words, to give them a very clear meaning, it would have given guidance to trial judges in interpreting new laws and understanding how the new firearms laws are supposed to be applied. While the Supreme Court of Canada obviously can't do a prospective interpretation, if they take the meaning of the words consistent with the purpose of the statute and the context in which they appear, it's likely that their interpretation would carry the day in any event, which could prevent a lot more cases from being either argued, appealed, or a lot more people from being charged in circumstances where, like Mr. Rana was of at least one of the offenses that he was charged with, ultimately acquitted and found not guilty. The Supreme Court of Canada had an opportunity to deal with an emerging area in criminal law that the federal government and the public have a particular significant interest in, and unfortunately they missed the opportunity to do so. There will be more cases involving the interpretation of firearms laws and how the new firearms laws and the old firearms laws interplay with one another throughout the course of the next several years of Canadian jurisprudence. But unfortunately, Mr. Rana's case won't be one of them. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.